Thank you. So today our presentation is entitled, Hey, Do You Have a Minute? And the reason that we chose to call it that is we know that oftentimes the end of the workday will be when someone comes and knocks on your door, and inevitably if they say, hey, do you have a minute, they probably want to talk about taking some time off from work. So we wanted to provide information for small businesses to help navigate this process with the Connecticut Paid Leave Act benefits becoming available in just a few short weeks, as well as let you know about some changes to Connecticut FMLA that will impact your business. Just a quick introduction. My name is Jessica Vargas. I am the Senior Marketing Director here at the Connecticut Paid Leave Authority. I have over 15 years of experience in broadcast media, marketing and communications. And I am a lifelong Connecticut resident with the exception of 4 years in Dallas, Texas, when I was earning my degrees in advertising and Spanish. And I'm joined this morning by my colleague, Kathy, and I'll let Kathy introduce herself.
Good morning, everyone. My name is Kathy Mihailuk, and I'm the Benefits Process Lead here at the Connecticut Paid Leave Authority. My background includes 20 years of HR experience in HR operations, benefits, and benefits administration. I have a bachelor's degree from Sacred Heart and a master's in communication arts. Thank you for joining us this morning.
So today, here's a brief agenda of what we're going to talk about. So obviously, we'll give you information about the Connecticut Paid Leave Program. We'll also talk about FMLA and how it relates to Connecticut Paid Leave. They are two different laws, but they're so intertwined that it really is impossible to talk about one without the other. Then we'll talk about implementing the Connecticut Paid Leave Act and implementing some of the changes coming to Connecticut FMLA. We will provide you with some additional resources where you can look for more information. And as Amber mentioned, please do submit your questions as we're speaking, but if there are any additional questions at the end, we will have time for Q&A. First, we want to give you a brief overview of the Connecticut Paid Leave Authority. The authority is a quasi-public agency that oversees the paid leave program, and we have 5 key responsibilities. The first is outreach and engagement, so making sure that everyone who's impacted by the Connecticut Paid Leave Program knows both their responsibilities and what benefits may be available to them. Developing the policies and procedures needed to run the program. Establishing the trust fund contribution rate and receiving contributions. We also approve and audit private plans, and private plans are for those businesses that might want to elect their own plan, insurance plan, instead of participating in the Connecticut Paid Leave Plan. And finally, in partnering with our third-party administrator, AFLAC, we will be administering benefits and approving claims for paid leave benefits come January. So just some key dates to kind of walk you through where we've been over the past year. Just about a year ago, end of November of 2020, employer registration opened, and that was when we asked businesses to create an account with Connecticut Paid Leave in preparation for contribution deductions, which began on January 1st, 2021. That's when businesses began deducting 0.5% from their worker paychecks. And those payments are submitted to the Paid Leave Authority quarterly. And there's a 30-day grace period at the end of the quarter. So for example, first quarter payments, the final deadline for those was April 30th, and so on and so forth. In February, we began accepting private plan applications, and we continue to accept those. So it is something that someone can apply for a private plan at any time. Starting in December, on December 1st, we will begin accepting applications for employees who know of an event that's happening on or after January 1st for which they would like to seek paid leave benefits. And then starting on January 1st, we will begin to pay out benefits for those approved claims. Let's talk about who's covered and who's not covered by the Connecticut Paid Leave Program. So the majority of businesses who have 1 or more people working in Connecticut are considered covered employers and therefore do need to deduct those 0.5% contributions and remit them. And that does include nonprofits and private sector employers with a unionized workforce. Now, sole proprietors or self-employed individuals are not required to participate in the paid leave program. However, they can opt in if they choose to. The only caveat is that they must stay in the plan for a minimum of 3 years if they do decide to opt in. We do have some exclusions. So employees of the federal government are not covered by paid leave. Unionized employees of the state of Connecticut are also not covered, except as to covered public employees, which we'll talk about in just a minute. And the same for municipalities and local or regional boards of ed. They are not covered unless they have covered public employees. Non-public elementary or secondary school employees are also not covered. Then there are a few entities that are not covered because of other laws that apply to them. So one is railroad workers, as well as individuals who are employed by the government of other states. So a Connecticut resident who works for the state government of Massachusetts, for example, would not be covered. Employees of sovereign nations are not covered. That includes employees of Foxwoods and Mohegan Sun. Employees who are engaged in interstate commerce in Connecticut but live in another state. So that would be truck drivers. And then spouses of active duty military who continue to pay taxes in their home state instead of the state where their spouse is deployed are also exempt. I mentioned covered public employees in a few of those instances. So let's talk about what that means. Covered public employees includes non-unionized employees of the state of Connecticut. It also includes unionized employees of the state if they collectively bargain to be included in the program. And for municipalities and boards of education, if the unionized employees do collectively bargain to be included, then all employees, both union and non-union, are included and considered covered public employees. Now, I mentioned a bit about sole proprietors and independent contractors and just wanted to go into that in a little bit more detail. So if you pay self-employment taxes as defined by the IRS, you are not considered an employee and therefore you don't have to participate in the program. As I mentioned, you can choose to enroll if you would like to. And if you do, you stay enrolled for a minimum of 3 years and your contribution rate is the same as all other employees participating. So it's half of 1% of self-employment earnings. If you're a sole proprietor and you have employees, even if you choose not to opt into the program for yourself, you do have to register with the Connecticut Paid Leave Authority and deduct those contributions from your employees. If you receive a W-2 from the business, you are considered to be an employee under the law. And therefore, you do have to participate in the program. And that's true even if you're the owner or the officer of the company. So as I mentioned, the contributions are 1/2 of 1%. Employers deduct those from employees through a payroll deduction. And the contributions are post-tax and they're based on the employee's FICA wages. There is a cap. So the contributions are capped at the Social Security contribution limit, which is currently just shy of $143,000. So even an employee who earns more than that would only contribute the maximum, which works out to be $714 a year currently based on the current contribution limit. The employer remits those contributions quarterly to us here at the Paid Leave Authority. We receive the contributions, we verify that they're correct based on other data that we have. And we deposit the contributions into the Paid Leave Trust Fund, and that is the fund from which benefits will be paid starting in January. So now we want to talk about what is FMLA and what is Connecticut Paid Leave and how do they work together. So you may be familiar with FMLA. FMLA stands for the Family and Medical Leave Act, and there are both a federal law and a state of Connecticut law. Both laws say that employees can take time off of work for an eligible covered reason, certain family and medical reasons, which we'll talk about, but that leave is unpaid. So employers are allowed to adopt policies to provide for income replacement. So for example, some companies will provide 6 weeks of paid maternity leave, for example. Employers may do that, but they're not required by the law to do that. The requirement of the law is that if someone is taking time away for a qualifying reason, that their job is protected and that they're returned to that same position upon their return to work. Now, there are some pretty significant changes happening to FMLA in 2022 that will essentially make it so that every business in Connecticut with one or more employees has to consider whether an employee is eligible for job protection if they take leave. Let's talk about what those changes are. So the hours worked requirement for eligibility for job protection under FMLA will be going away. Currently, it's 1,000 hours, but starting in January, there will no longer be any hours worked requirement. Additionally, right now, job protection doesn't kick in until 12 months of employment, but that will change to 3 months of employment in January. As I mentioned, FMLA will apply to businesses with 1 or more employees. Currently, the law applies to 75 or more employees. And there will also be some expanded reasons for leave, which include family violence and an expanded definition of family. And of course, the addition of paid leave for those who qualify. So currently, this chart just sort of shows side by side the differences that we just talked about. Currently, businesses with 75 or more employees must consider FMLA. That will change to 1 or more. I mentioned that the job protection is currently after 12 months. It will change to after 3 months, and that hours worked requirement will go away. Another change is that the amount of time a person can take for for job protected leave will change. So currently, there's up to 16 weeks of leave available in a 24-month period. That will change to up to 12 weeks of leave available in a 12-month period. Now, currently, there are 26 weeks of leave available for military caregiver leave, and that will remain the same next year. But in addition is that there will now be an additional 2 weeks of leave available for incapacitation during pregnancy starting in January. And then a really key point that I want to make sure that you know is that right now, an employer can request and require that their employee use any accrued PTO for their leave. So vacation time, sick time, anything like that. But starting in January, the employer can still require employees to use PTO, but they can't require them to use all of it. If the employee wants to retain up to 2 weeks, the employer has to allow them to retain up to 2 weeks of PTO to use at a future for a future reason. So that's a pretty significant change to keep in mind. Now, Connecticut paid leave provides income replacement, but not job protection. So that's sort of the intersection of FMLA and Connecticut paid leave. Previously, if someone was taking time off for a qualifying reason, they would have that job protection, but they may or may not have had income replacement options through their employer. Now, Connecticut paid leave will provide those income replacement opportunities. When you hear the acronym CTPL, we sometimes are referring to the statute, the Connecticut Paid Leave Act. We also use it to refer to the program itself and to ourselves here at the authority. So key takeaways, the Connecticut Paid Leave Act creates a source of income replacement benefits for eligible employees who are taking time off for qualifying reasons, but it does not provide job protection. And so there are circumstances where an employee might be eligible for Connecticut paid leave benefits, but not for job protection under FMLA or vice versa. You may also hear the acronym PFML, or paid family and medical leave as a term, and that is also referring to Connecticut paid leave. Now, what are the reasons that an employee could apply for job protected leave and or income replacement benefits? The first is medical leave. So medical leave is the term used for leave taken by an employee to attend to their own serious health condition. And serving as an organ or bone marrow donor does qualify as a serious health condition, as does pregnancy. There's bonding leave. Bonding leave is leave taken by a parent to bond with a new child who has entered their home through birth, adoption, or foster care. Both mothers and fathers can take bonding leave, and the leave can be taken at any time within the first 12 months, either of the child's life or of their placement in the home in the case of adoption or foster care. In the case of adoption or foster care, bonding leave can also be used for pre-placement activities that the employee needs to attend. Caregiver leave refers to an employee taking time off to care for a loved one who's experiencing a serious health condition. Family violence leave, this is unique to Connecticut. Family violence leave can be taken by someone who is a victim of family violence. Some of the reasons might be obtaining services from a victim services organization, seeking medical or psychological care, relocating, or participating in court hearings resulting from the family violence. And for family violence leave, up to 12 days in a calendar year can be used. Then we have 2 types of leave that apply to the military. The first is called qualifying exigency leave. And this is leave that can be taken by a spouse, parent, or child can be taken to address activities arising from a spouse, child or parent who's on federal active duty or who has been notified of a call to active duty. So for example, there might be the necessity to visit an attorney before the person is deployed or to get some financial things in order. Those would be reasons for qualifying exigency leave. And then lastly is military caregiver leave. That is leave taken by a worker to take care of a family member who was injured in active duty in the armed forces. Now, a special note for caregiver leave, under the Connecticut law, the employee can take caregiver leave and apply for paid leave benefits for any of the relationships that you see on the screen. Parent, spouse, son or daughter of any age, sibling, grandparent, or grandchild. But there's also the ability for an individual related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of those family relationships that I just listed. Someone can take caregiver leave for someone that they are related to by affinity. So any person with whom the employee has a significant personal bond that is like one of those family relationships that we just listed, regardless of the biological or legal relationship. Here are a couple of examples. One could be an aunt or an uncle who relies on the employee for unpaid care, and that relationship between the employee and the aunt or uncle is like that of a parent and a child. That could be considered related by affinity. A more common example might be an unmarried couple who perhaps share a home, share bills, maybe have children together, but they're not married. So legally, they have no relationship to each other, but they are related by affinity and therefore could take job protected leave or apply for income replacement benefits to care for their significant other if they were ill. We're going to now take a look at the federal job protected leave under FMLA, the Connecticut job protected leave, and then Connecticut paid leave benefits and the eligibility for each one, because it is different for each type of leave or benefit. The federal FMLA is not changing. Federal FMLA applies to businesses with 50 or more employees. And in order for someone to be eligible, they must have been employed for at least 12 months with that employer, and they must have worked for at least 1,250 hours in the 12 months immediately before their leave. Now, Connecticut FMLA, this is starting in January, employed by the employer for at least 3 months to be eligible and no longer any hours worked requirement. And then for someone to be eligible for Connecticut paid leave benefits, there's an earning requirement and an employment requirement. So the earning requirement is that that person must have earned at least $2,325 in the highest earning quarter of the first quarter of the past 5 quarters. That's what we call the base earnings period. And that $2,325 can come from more than one employer. So if there's a part-time worker who holds 2 or 3 jobs, as long as the total wages from those 3 employers add up to $2,325 or more, they would have met that minimum earning requirement. Additionally, the person applying for paid leave benefits must be currently employed and working in Connecticut with a covered employer, or had been employed and working in Connecticut with a covered employer within the past 12 weeks immediately preceding their leave. Just as another note and mention, sole proprietors or self-employed individuals who have opted into the program can participate. They must also be residents of Connecticut. Now, what are the entitlements? So how long can people apply for benefits for under these 3 different laws? For federal FMLA, there's up to 12 weeks available in a 12-month period for all leave reasons, with the exception of military caregiver leave, which is up to 26 weeks in a 12-month period. Connecticut FMLA, starting on January 1st, will reflect the federal FMLA in that there will be up to 12 weeks in a 12-month period for all leave reasons, except 26 weeks in a 12-month period for military caregiver leave, which again reflects the federal law. But unique to Connecticut is up to 12 days in a calendar year can be used for family violence leave. And the employee may be eligible for an additional 2 weeks if there is incapacitation during pregnancy. Now, the Connecticut paid leave benefits are similar. So up to 12 weeks in a 12-month period for all leave reasons, including military caregiver leave. That means that someone who is taking military caregiver leave could be eligible for up to 26 weeks of job protection, but only 12 weeks of income replacement. Up to 12 days of the 12 weeks can be used for income replacement during family violence leave under Connecticut paid leave. and those additional 2 weeks of income replacement for incapacitation during pregnancy may also be available under Connecticut paid leave. So now I'm going to hand it over to Kathy, and she's going to talk about the implementation of the Connecticut Paid Leave Act.
Thank you, Jessica. Good morning, everyone. Next slide, please. We're going to talk about the responsibilities that each different area of the Connecticut paid leave claims process. We're going to start with the worker. So the employee or worker needs to submit an application for Connecticut paid leave. How they do that is they go to the Connecticut paid leave site and they create a Connecticut paid leave account where they would set up a user ID and a password. Once they're in the system, they will have a prompt that will pop up and take them to the AFLAC portal asking them, would you like to submit your claim now? So at that point, if the employee has all the information that they need to file the claim, they would then provide the supporting documentation, update their information with their absence information, such as the start and stop dates, and then, of course, notify the employer that they plan on taking a leave and that they have applied through the Connecticut paid leave program. As part of the process, there is what's called an employment verification form that needs to be completed by the employer. Information such as the employee will complete the top portion of the employment verification form, and then most of the form will be completed by the employer. Information such as employer name, address, most importantly, contact information, the name of a person to contact, a phone number, and an email address. So if there's any incomplete information on the employment verification form or more information is required, we can easily reach out to the employer to get the information requested. When the employee comes to the employer and with the employment verification form, that is also an opportunity for the employer to notify the worker about its PTO policies, including short-term disability. The Connecticut Paid Leave Authority works with AFLAC. AFLAC is our TPA, who would then determine eligibility by reviewing the supporting documentation and approve and or deny claims as appropriate. AFLAC will calculate and pay the benefits and will monitor the claims on an ongoing basis. They will also assess requests for what's called reconsideration. Reconsideration occurs when, let's say, a claim was submitted and then it was denied. And the employee can then call back AFLAC and say, you know, I want this case reconsidered. I didn't submit the proper documentation. I didn't understand, whatever the situation is. Once a claim is either approved or denied, the employee would be receiving communication from AFLAC, letting them know the status. So if a claim is denied, they would have the instructions in either an email or a letter, letting the employee know what steps they need to take for this process. AFLAC would also investigate potential fraud, if there are any fraudulent claims, and impose penalties as appropriate. If a claim is denied and the employee wishes to appeal the process, in the letter will be instructions as to how to contact the Connecticut Department of Labor. The Connecticut Department of Labor will be handling and hearing appeals related to Connecticut paid leave denial of claims and to any imposed penalties. So the worker submits the claim. Ideally, the claim is submitted at least, by 30 days prior to the start of the leave. The worker would go to the portal on the Connecticut paid leave site, create an account, and then submit an application for a claim. Information will be required, such as the reason for the claim, the length of the leave, the type of leave, and other job information or other sources of income. AFLAC reviews the information and determines the eligibility. AFLAC will be using earnings from the DOL data, DOL website, and they will validate that the worker is working for a covered or registered employer or sole proprietor. If it is determined that the employee or worker is not eligible, AFLAC will notify the worker and offer the right to request reconsideration. If the claim is approved, AFLAC reviews the supporting documentation, including the employment verification form. Now, an important note during the 30-day process to file a claim, the employer will receive the employment verification form from the employee. The employee will give it to the HR department or whoever the person is handling the leaves. The employer needs to fill out that form, and they have 10 days from the date they receive the form to complete it. So that you have 10 days from the date you receive the employment verification form to get it back to AFLAC. On the form is the email address and the fax number to get that information over to the AFLAC. If the claim is denied, AFLAC notifies the worker and offers the right to request reconsideration. As another footnote, if the claim is either approved or denied, we will be sending by email preferred to the employer, letting them know that this claim for this employee has been approved, the type of leave, the start and end date of the leave, and then the weekly benefit amount. So AFLAC is responsible for calculating the benefit amount. They use the DOL data, and then there is information that is on the employment verification form that is completed by the employer, and that's used in the process to calculate the benefits. Employees or workers have two different ways that they could receive the funds: via electronic transfer, which would be direct deposit, or what is called a stored value card, which is like a debit card. Benefits are issued each Tuesday, and they are paid 2 weeks in arrears. For example, let's say someone is out on leave from January 2nd to January 8th, the check will be issued on January 18th. If an employee ever has any questions about the benefit calculation, benefit payments, I didn't receive my payment, they need to contact AFLAC directly. The worker is responsible for contacting AFLAC of any changes. For example, let's say someone originally was filed a claim to take leave of absence January 2nd, and now they decided, oh, I'm going to take the leave January 20th. They need to notify AFLAC of any start or end dates that have changed, or if they're in receipt of other income. If the worker is taking intermittent leave, they must provide frequent updates to AFLAC about the leave usage. Here's a sample copy of what's called the employment verification form. The top portion of the form is completed by the applicant or the worker. There's the employer information to be completed by the employer. The employer name, contact name, the preferred method of communication. So for example, if you would rather get a letter in the mail through the US Post Office than an email, you would check that off. But we also have email, which is the preferred method because it's faster. You can check that off to receive any information or correspondence regarding the worker that is on Connecticut paid leave. It's very important to have a contact phone number or contact email. If we have any questions about the information you provided about this employee, for example, the date of hire or that the person terminated, or something that is, AFLAC may have questions about the schedule, we need to have a phone number or email address, preferably both, where we can get the missing information and process the claim in a timely manner. Here are some examples of benefit payment calculations. Column A, if a worker earns minimum wage, which is $13 an hour currently, the benefit is 95% of their base weekly earnings. For example, an employee makes $13 an hour, they're working 40 hours a week, 40 times 13 is $520 a week. Their benefit is 95%, which 95% of 40 hours times $13 is $494. The worker A, would receive $494 in benefits. Worker B, let's say the minimum wage, they make more than the minimum wage. Let's say they make $13.50 an hour and they are working 40 hours a week. The base earnings are 40 times $13.50, which is $540 a week, at 95%, which is the $494. The added portion of the formula is plus 60% of the $540 minus $520, which gives us a difference of $12, making a total amount of $506 for worker B, who would receive that amount in benefits. Now, the good news is, on the Connecticut Paid Leave website, there is a benefits estimator that people can use. When you go to the website, there is a blue banner at the top of the page, and the second item will be called the process. Once you click on the process, there's a drop-down menu. It'll then say, prepare to submit a claim. And then you go through that site or through that page, and you will see where it'll ask you, or there'll be a section on benefit estimation. So we gave you the example of how to calculate a claim, just so that you would know how it's done. But this would be a probably a more streamlined and more efficient way of calculating the benefit amount.
Yeah, I just wanted to jump in really quickly and just point out that there is a cap on the maximum benefit amount, and it's 60 times the Connecticut minimum wage. So right now, the maximum weekly benefit amount would be $780, so 60 times $13.
Right, and a key factor in all of this is that an employee is never to receive, with any PTO, short-term disability, they're never to receive more than 100% of their pay. Okay, so here we have 4 separate scenarios as examples to help you with any PTO or short-term disability questions. Scenario number 1, let's say you have a worker who has no PTO to use. If the worker has no PTO, then the worker, when they apply for the claim for the Connecticut Paid Leave benefit, they would receive the benefit for the full period of the leave. Scenario number 2, let's say a worker has enough PTO to cover the entire leave. For example, let's say an employee goes out for 4 weeks and they have 4 weeks of PTO. Then there would be no Connecticut Paid Leave benefits to the worker, because they would be getting paid their full regular pay during that 4-week period. Scenario number 3, the worker has PTO to cover part of their leave. If the worker has available PTO with their regular pay that covers part of their time out, then the Connecticut Paid Leave benefits will start after the PTO benefits from the employer are exhausted. Okay, and this is minus the 2 weeks employees are entitled to keep. This is in reference to Connecticut FMLA, where effective 1/1/22, as Jessica had mentioned in earlier slides, that employees are entitled to keep 2 weeks of their PTO time effective 1/1/22. Scenario number 4, PTO is less than the worker's regular pay. Worker has PTO that's less. They get their benefit at the start of the leave, but employers can coordinate the benefits to make up any wage differences. Again, employees can get no more than 100% of their regular pay. So what do your workers need to know? First, when they come to the HR department or they go to their employer, they need to find out their employer paid their policies for PTO while they're out on leave. Are there any rules of using such time, such as can they use sick time, vacation time? That would be according to the policy of the employer. If you offer a short-term if you offer a short-term disability policy, does the policy state that the worker must exhaust other employer-provided PTO and Connecticut paid leave before accessing the short-term disability benefits? Or will the short-term disability policy reduce any benefits paid by Connecticut paid leave or similar benefits received? I would suggest that everyone review their short-term disability policy so that you would know how to coordinate the benefits with PTO and Connecticut paid leave in relationship to short-term disability. Implementing Connecticut FMLA. Now, we're going to be talking about Connecticut FMLA, and we just finished talking about Connecticut paid leave. The process for Connecticut FMLA claims, again, the worker notifies the employer in a timely fashion that they have a need to take time away from work. They submit the application and provide their employer with the supporting documentation. The worker complies with the employer attendance and call-in policies associated with taking a leave of absence. The employer has established leave policies and rules about PTO usage. They process the leave requests, monitor the leave usage, and manage the worker's return to work. It is discouraged for employers to discriminate or retaliate against workers for FMLA usage. Now, the Connecticut Paid Leave Authority has no official responsibilities related to Connecticut FMLA. However, we have decided to provide information about the Connecticut FMLA as part of the Connecticut Paid Leave training. Connecticut Department of Labor is available to provide guidance to workers and employers about Connecticut FMLA, and they'll also investigate complaints about denials of claims, possible discrimination, and/or retaliation. So the Job Protected Leave Process, FMLA. The worker notifies the employer they need to take time off from work, preferably 30 days in advance, and as soon as practical. If it is an emergency and the person cannot give the 30 days in advance, I mean, these things have happened in the past, and then you just process the paperwork accordingly. The employer will determine if the worker is eligible for Connecticut FMLA and notifies the worker if they need to provide any additional documents. The employer has 5 business days to notify the worker of eligibility and provide the notice of rights and responsibilities. Please note, this is not the leave approval. The worker provides the required documentation, such as the medical certification, adoption documents, military records, for example. The worker has 15 calendar days to provide this documentation to their employer. If the worker notifies the employer of difficulty obtaining these documents, the employer should give the worker additional time. There have been instances in the past where perhaps physicians' offices, healthcare providers have taken longer than usual to submit or to complete medical certifications. This is a trend that has continued, especially through the COVID-19 pandemic that we've all experienced in the last year and a half. The employer then notifies the worker if the leave is approved once they have all the documentations that they need. The employer has 5 business days to process the required documentation supporting the leave request. The employer must notify the worker if they're required to use paid leave accruals, how the worker will need to report in, and if the worker will need to provide a fitness for duty before returning to work. The worker reports to the employer when the worker actually takes the leave, and it is the employer's responsibility to track the leave usage so it does not exceed the 12 weeks. I've seen people track the utilization through payroll, through Excel spreadsheets, or what other HRIS or IT programs that you may have at your employer. The employer returns the worker to the job the worker held before the leave. as the worker has a right to return to the same job with the same terms and conditions. The employer cannot insist that the employee be 100% fit for duty or totally recovered. The employer must consider ADA and CFEPA obligations. Complicating factors for managing FMLA. Managing worker absences, enforcing attendance and call-in policies, and getting timely notices from workers or supervisors about absences. In many cases, sometimes this information is received after the fact, after the payroll cutoff date. However, if you have a process in place and educate the supervisors and workers as to what the policies are, this would help in cutting down the, this would be helpful in getting timely notices from workers and supervisors about absences. Managing intermittent leave due to unforeseen circumstances, and calculating the average work week for workers with fluctuating work week schedules. Incomplete or insufficient medical certifications can delay the process. And then also managing the interaction between CTFMLA, federal FMLA, and other laws. If the if the worker or employee does not want the leave to be designated at FMLA, it is the employer's right and responsibility to designate the time off that it qualifies under FMLA, even if the worker doesn't ask for it. Overview of leave laws. There are a number of laws providing job-protected leave. We have the federal FMLA. We talked about the Connecticut FMLA before 1/1/22, and then the changes that are in effect for 1/1/22. Workers' Comp, Americans with Disabilities Act, 15+ employees. The Pregnancy Disability Act for 15+ employees. The Connecticut Fair Employment Practice with 3+ employees. Then we have laws providing income replacement, Connecticut Paid Leave Act, and workers' compensation.
Thank you, Kathy. So we want to just leave you with some additional resources where you can get more information. We have 2 toolkits that you can download from our website. One's called the Employer Toolkit and one is called the Human Resources Toolkit. And I would advise looking at both of them because they have the information we just went over as well as some more in-depth information that will be really helpful. We also have several different employee-facing documents. So we have the employee rights poster, RAC card, an employee fact sheet. And we would really advise sending your employees to our website for more information as well. We do not have a call center just because the cost is very prohibitively expensive, but we do have a contact us portal that you can access through our website, which is ctpaidleave.org. And so if you have a question, we would ask that you just write in through the contact us portal. When you do so, if you would prefer to have a call back from someone instead of an email, we can do that. You would just indicate that, and then one of our representatives would call you back within 2 business days. Also on our website, we have several hundred frequently asked questions that can be very useful. And on our YouTube page, we have a bunch of helpful videos, both for employers and employees, explaining more about the process. One other piece of advice is if you do have any employees who you know are going to be applying for benefits, maybe they're pregnant and expecting in the new year, something like that, they can begin to create an account with Connecticut Paid Leave now so that they're ready to submit their application starting in December. And there is a tutorial video on the website that you could direct them to give more information about starting that process. So we thank you so much for joining us. We know we gave you a lot of information. I know there are a few questions that I believe are in the chat, but I'm not sure if Amber was able to answer them all already. Let's just see so we can answer these. Okay, if an employee is out on Connecticut FMLA leave starting on January 1st, 2022 to take care of grandmother and takes 12 weeks, but on June 1st, 2022, the same employee needs time for their own serious illness, Will they be entitled to 12 weeks based on the federal FMLA? Kathy, do you want to answer that?
Sure. Cecilia, it depends. When they take the Connecticut FMLA on January 1st, if they at the same time apply for the federal FMLA and take the 12 weeks at that time, then they don't have any more time under the federal FMLA. So it's going to take coordination when someone goes out on leave, and it has to be very specific as to what types of leave the people are applying for. So they don't have 24. They would have, if they, with the Connecticut FMLA, if they applied for the federal FMLA at the same time, you know, then they would run simultaneously.
Thank you. Another question, are per diem employees eligible for job protection after 3 months? Are they eligible for Connecticut paid leave if they meet requirements of 23-25 in the highest earning quarter of 4 of the past 5 quarters?
I guess the question would be, are they having that 0.5% come out of their pay?
Right,
So whatever, yeah.
Yeah, if they're working for a covered employer, since there is no hours worked requirement, if they were working for a covered employer and had been for at least 3 months and they met the earnings requirements, then yes, they would be eligible for Connecticut paid leave. Another question, can you explain the implications of no job protection in connection with using paid leave? How and when can an employer terminate an employee using paid leave? Does a terminated employee have any protections under Connecticut paid leave, the CTPLA, I'm assuming that's Connecticut Paid Leave Act, if terminated for using paid leave?
So I can take this, Jessica, as I ran into this before. If an employee, let's say they're not eligible for FMLA or Connecticut FMLA, so they don't have any eligibility under the job protection leave, and they're only eligible for Connecticut paid leave. If an employer decides to terminate an employee, the Connecticut paid leave program is only income replacement. It is not job protection. And what the employer would have to do at that time is look at their not absence management, but their termination policy, like whatever their policy is for the employer. There is no job protection under Connecticut paid leave. It's only income protection.
And if I can add to that, Kathy, typically the reasons that someone would be applying for paid leave do mirror the reasons someone could apply for FMLA. So most often there probably will be a job protection element under FMLA, but for example, someone could qualify for paid leave because you know, perhaps they just changed jobs, they're working with a new employer, so they don't have the 3 months yet, but they had been working with a different employer who was covered in the 12 weeks preceding their leave, and they met the minimum earning requirement.
Correct.
So in that case, they would be able to apply for paid leave benefits, but they would not be able to have job protection under FMLA because they did not meet the minimum length of time.
Great, thanks for that example, Jessica.
And then one question that just came into the chat, what if someone has a baby on December 23rd, 2021? Are they able to go on Connecticut PF paid leave, excuse me, in January?
Well, they would have to go through the application process and apply for benefits, but yes, they would be eligible to go on Connecticut paid leave. You're eligible to apply, and you would have to submit your paperwork and get approved through the process through AFLAC.
Yes. But for bonding leave, it can be taken at any time within the 12 months following the child's birth. So those 12 weeks would be available for this person between January 1st and December 22nd, 2022, essentially.
Correct. That is correct.
Another question that just came in, our short-term disability policy does not reduce the benefit for any other income such as Connecticut PFML. If the amount the employee receives from our short-term disability plan plus Connecticut paid leave benefit is less than 100% of their wages, will the employee be able to receive the full amount of Connecticut PFML without any reduction? All
right, so let me understand this. Does not reduce.
So short-term policy. Yep. Does not reduce any other income. So if the amount the employee receives from short-term plus Connecticut paid leave is still less than 100% of their wages, can they receive the full amount of Connecticut paid leave?
Yes, if it's less than, it's just that when it's when it's over the 100% is when it, of course, becomes an issue. But if it's less than, then it's not a problem.
Thank you,
You're welcome.
Kathy. And to Christine, she asked, will we be making the presentation available? Yes, the presentation is recorded, and in a few days, Amber will send out a recap with a link to this presentation so that you can rewatch it. We also have several other webinars coming up. If you look on our events calendar, there are many, many more webinars coming up. And we do have some that are specifically geared toward workers. So if you have someone who you know is going to want to apply for leave based on having a baby or having a planned surgery or something, you can certainly send them to that section on our website, and we'd love to have them join us. I don't see any more questions coming in. So we will give you all back a couple of minutes of your morning, but thank you so much for joining us. We truly appreciate it. And please do reach out through our contact us portal if there are any other questions that come up. Thank you, everyone. Have a great day.
Thanks, everyone.